Hello, and welcome to Rules of the Game, where we demystify the laws that govern nonprofit advocacy so you can push for change boldly and legally. New to advocacy? Start with the basics at afj.org.
On this edition, we open up the docket and get an update on the variety of court cases that impact tax-exempt organizations and their ability to advocate on the issues they care about. And to help with that, we're joined once again by friend of the pod, Emma Olson Sharkey from Elias Law Group, to help demystify what's happening in the courts and how it might impact you and your work. Emma, welcome.
Thank you very much. Glad to be here.
As I said off mic, 2 more until the 5-timers jacket. It's happening. We're just going to have to go get some embroidery done. We're also joined by Brittany Hackard-Leonard. Hello, Brittany.
Hello. I'd like a jacket as well if you're ordering.
I think you've done 5 episodes. I think we just need to do a bulk order here. So that's happening. As mentioned before, this is a bit of a litigation update. So we are going to be talking about the variety of cases that are at the federal and state level that are impacting the work that we do, the work that we cover here on the pod. And so we're going to start off, Brittany, with introducing a case that we've been paying a lot of attention to, and that's the Freedom Path case. Also the Memorial Hermann case, because they're lumped together in the same issue that's super important to 501c4s. So Brittany, take it away.
Yeah, that's exactly right, Tim. So these 2 cases are on a similar topic. We'll start out with a little summary of the Freedom Path case. So this is Freedom Path Inc. versus IRS, and it's being discussed in the U.S. District Court for D.C. And basically the question there is, for 501c4s, what is going to count as that non-exempt political activity, and how much of that activity can a C4 be doing? Here we had Freedom Path, an organization who applied to be a C4 with the IRS and was denied, which led to this case. So the question here is whether the standard that the IRS used to deny them was unconstitutionally vague. So this is really that facts and circumstance test that we hear a lot about. And remember, for 501c4s, their primary activity needs to be that nonpartisan activity, stuff that a 501c3 can do. But their secondary purpose can be that non-exempt political activity. So what we're talking about here is, what is that proportion of primary purpose and secondary purpose, and how are we defining what falls into that secondary purpose category? So where this is right now is that the judge has ruled that our facts and circumstance test that we're all familiar with, that is unconstitutionally vague as applied to this case. But the judge said all of your other suggestions for tests, they're also unconstitutionally vague. So we're in this position where there is no proposed test right now that's going to be more clear. So the judge said, I want more briefing on this. I want you guys to go think about this and come back with tests that might be more clear. So that briefing is due this April 2026. And there's a hearing that has been set as of now for May 2026. So we'll see if the judge likes any of these proposed options. One tricky thing here is that Congress has banned the IRS from making new standards to apply to the C4s. So this was something that was added into an appropriations bill as a rider. But as a result of this, we're in this weird position where even if a new rule is created, it's not clear how the IRS could accept that rule or apply that rule without some sort of act of Congress to lift that ban, which we know is Congress is not the most efficient body at the moment. So we'll see where that goes. That's the status of that for now. And then we have the second case, Memorial Hermann, which is on the same topic. This was heard in the Fifth Circuit. And really what happened, again, we had that issue of what counts as a primary purpose for 501c4s. In that case, we had a hospital system that was doing a lot of work that would not fall into that primary purpose category. And so the question here was, what standard do we apply to determine how much needs to be done to count as that primary purpose? So the test that the judge there applied was the substantial non-exempt purpose standard, which is one of a couple different potential standards the judge could have applied. But essentially in that case, the judge didn't answer the question of exactly how much secondary activity is okay for a C4, and they just said that 49% was probably likely too high to count as a secondary purpose, but they didn't give us that exact line. And this case is unique because in the facts of this case, there was a lot of commercial activity, a disproportionate amount. So we're not quite clear if that's going to set a standard for other cases or if this was just going to be unique to this case. But essentially, this case is now dead. But again, it didn't resolve that issue. So we could see this coming up again. And we're seeing similar issues play out in the Freedom Path case in DC as well.
And if you remember from back about a year ago, we had Larry Gold on the show. We talked about that case. And yes, that was the episode where I referred to the Fifth Circuit as the crazy uncle circuit, because it is. Emma, what do you think about these cases and what this all means, especially for our 501c4 friends who are advocating and doing political activity and now have a little bit of a moving target now?
Absolutely. I 100% agree with everything that Brittany said. And ultimately, the line here is now unclear. So practically what I recommend for folks that are in this system engaging in as 501c4s is that they actually track these litigations closely, watch their movements, and then also talk to their counsel about what makes sense for them in this moment, knowing the activity that they're going to engage in. And practically, this will matter for organizations that 501c4 organizations that want to do a lot more political activity as compared to those that are much more focused on social welfare activity. So educational activity, advocacy, ballot measure advocacy, those are more squarely in the primary purpose activity lane.
Yeah, that's a really good point, because ballot measure activity sometimes gets a little confused. And of course, as we've talked about on the pod ad nauseum, it's considered lobbying activity within the concept of how the IRS looks at things. And so that's squarely in primary purpose activity. So you've got a lot of work you can do as a C4 on those types of things. And dog ear that, because we're going to be talking about ballot measures in a few minutes as well. I wanted to talk a little bit about administrative law, because again, we talk about things before we turn the mics on. And that's where I always like to brag that I got an A in administrative law back in law school, because it's my proudest A I ever got. So here, let's talk about the death of the Chevron doctrine, which was the basis of administrative law for basically all of our entire careers until a couple of years ago when Loper Bright came out. And we wanted to talk a little bit about the aftermath here of this. What did Loper Bright do? It did what I said. It got rid of what was for decades deference that the courts would give to reasonable regulations that were put out by administrative agencies. And Loper Bright basically said, no, we're not going to rely on the expertise of these administrative agencies. No, that's not going to happen anymore. We, the courts, who are not anywhere near the experts of the administrative agencies, we're going to institute our own independent judgment for anything that comes before us on these types of matters. And at the time, because this was such a sea change really for how all of this was litigated and how this was all administrated around administrative activity, which is really where the bulk of policy happens. A lot of us, especially for those of us who came from the environmental movement, where this was just something we dealt with all the time, we thought this was going to be a massive earthquake to how law worked, how litigation functioned, everything like that. And then here we are in 2026. And Emma, why don't you say what you think about all of this? Because I was a little surprised when I thought about it that it hasn't been as big of a deal as I originally thought it was going to be. And I'm curious what you think.
Yep, I agree with that. And when this court case came out, I think there was a legal reverberation across the country of, oh, what does this mean for us now in the short term and then also in the long term? And I still think we're seeing that play out in courts across the country. There are going to be decisions now and in the long term that will continue to take this position. However, the thing that I have seen and when talking to other practitioners is I am thinking more about the statute itself and how it would be interpreted by courts, not necessarily always thinking about the regulatory guidance, but also really thinking about how it would be interpreted by a court based on their independent judgment. And I think that a lot of practitioners are taking that point of view as well.
Yeah. And just because there hasn't been top of the fold headlines of impacts from this case doesn't mean that it's not going to happen down the line. And there's just been a bunch of things that have intervened since Loper Bright came out. And so maybe some of the energy just hasn't gone that direction. It's still a major change in how administrative law is administered. There I go, using administration, administered twice in a sentence for different reasons. English is a fun language. I did that offline too. Anyways, Brittany, do you have any thoughts on this before we move on to the next thing?
No, I agree with everything you both are saying. I think it remains to be determined how this is going to play out, but definitely something we need to be keeping an eye on.
Yeah, this impacts, I think, different areas of the progressive movement differently than others because, as I mentioned, environmental movement deals with this. Regulatory stuff is such a huge part of how the Clean Water Act, the Clean Air Act, these major linchpin areas of environmental law are handled, where the rubber meets the road in terms of their administration. So to be continued on all of that, and of course other areas as well. It's just, like I said, the area that I come from. We have the next one, and this one's yours, Brittany, because this one's interesting. This has been something that this administration has been interested in a while, and that is the removal of the Johnson Amendment. And there's been declarations that it's gone. There's been all sorts of quasi-non-legal declarations by the president and other folks saying, oh yeah, don't worry, you 501c3s can now do whatever you want around politics, or if you're a church, you can. It's a really muddled thing, but we do have a court case on this subject matter. So take it away and talk about NRB versus Long.
Yeah, thanks, Tim. So you may have gotten an A in admin law, but I got an A in First Amendment.
See, and this is the power team right here.
Yeah, I didn't even take admin law, so I'm glad you can cover that portion. But yeah, so like Tim said, the issue here is all about the Johnson Amendment. This is being heard in the Eastern District of Texas right now. We anticipate it will not stay in that court, and we'll see more from this case. But the issue here is whether the Johnson Amendment violates our constitutional rights or the rights of organizations to freedom of speech, free exercise of religion, and they've claimed a couple other rights are violated by this as well. So just a reminder, the Johnson Amendment is that rule for 501c3s that we must stay nonpartisan. We cannot support or oppose candidates for office, and that is in the text of the statutes and regulations that govern 501c3 organizations. We had a really interesting blog on the history of the Johnson Amendment that one of our interns wrote last summer. So if you're interested in checking that out and hearing more about how we got to the place we are today, I highly recommend that. But essentially how we got to this case is that a group of conservative religious organizations and the National Religious Broadcasters brought this suit together, claiming those violations of constitutional rights because they believe that they should be able to do politicking from the pulpit. They should be able to support or oppose those candidates in their religious organizations. While that was playing out, essentially in last July 2025, the IRS agreed to a proposed consent judgment with those plaintiffs and said that they would not defend the Johnson Amendment, essentially conceding that they were not going to enforce this rule against religious organizations. The scope of that we'll discuss is a bit complicated. This consent decree, again, that's just proposed, it hasn't been accepted by the court yet, says that the Johnson Amendment, as properly interpreted, does not prevent a house of worship from speaking to its congregation through customary channels of communication on matters of faith in connection with religious services concerning electoral politics viewed through the lens of religious faith. So that is the contents of this proposed decree. Essentially, those houses of worship, if they're using customary channels of communication, can engage in electoral politics, which would mean that the Johnson Amendment is not being enforced against them. So what has happened since July 2025 that has delayed this case a bit is that Americans United for Separation of Church and State, a C3 that you all may have heard of, intervened in an attempt to oppose this consent decree, because basically we have two parties consenting, so you need this outside party to come in and say that they don't agree to it for this to be halted or for the judge to refuse it. So that motion to intervene was filed, it was heard, it was denied in December 2025, right at the end of last year. And then they had 60 days to appeal that decision, which they did not do. So basically, we are back to where we started before they attempted to intervene. I believe they do have a leave to file an amicus brief, among other things in the case, but they will not be a party to the case. So right now, the position we're in is that we're expecting a final decision on whether that consent decree will be accepted sometime this spring. If it is accepted, we will likely potentially see more challenges along these lines. That will probably not be the last we hear about this. So I flagged a couple of potential issues here. Basically, we're hearing a lot of slippery slope arguments. So if you open the door here to not enforcing the Johnson Amendment to religious services or houses of worship, where do you draw that line? So the consent decree as written only applies to the specific plaintiffs in this case. But there's no reason to believe that it would stop there, that the IRS would enforce the Johnson Amendment to other houses of worship. There's also a history of them not enforcing the Johnson Amendment against houses of worship anyway. And then the other question is, what are these customary channels of communication that they're saying they're limiting this to? Is that going to include televangelists, people on TV doing church services? Is it going to include YouTube? Where is that line where this will stop? So Tim, Emma, any other thoughts about where this could potentially lead us?
This has been very focused on houses of worship. And since I did not get an A in First Amendment law, then it's a 14th Amendment equal protection question here about non-religious secular 501c3s and whether or not this disparate treatment has an issue constitutionally. And that's always been my thought process in all of this, because it's very clear that from a policy perspective, this administration is, this is all about churches and religious institutions and forgets about other entities, setting aside the question of whether this is a good idea at all anyways. But Emma, I'd love to hear what you have to say.
No, I 100% agree with that, actually. I do think this opens the door of other 501c3s having the ability to speak about political activity and endorse candidates and whatnot. And so I think that I will be interested to see about the consent decree and ultimately see what happens if it is accepted and if they move forward.
Yeah, and one more thing to flag here is just that we're already seeing some states try to make state-level Johnson amendments in response to this. We've seen things proposed in New York and Maryland, among others. So they're trying to put in these safeguards in case the federal Johnson Amendment falls. But it's unclear if this makes its way all the way up to the Supreme Court. Those could likely be struck down as well. So we'll see on that.
Now we got supremacy clause stuff going on. This is a con law seminar here. Let's pivot to the stuff that I think, Emma, you've got really fantastic in particular insight on. And that is what is happening at the state level regarding ballot measure access. There are a host of cases that we've got in the show notes, and you're going to mention a bunch of states here.
Yep.
What's going on and how is this impacting kind of from a progressive perspective, access and everything that's going on there?
And so to take a step back, what we've seen over the last 5-10 years is just a crush of legislation across states that is an attempt to restrict the ballot measure process in a multitude of ways. So it's restricting who can circulate a petition, it's restricting the petition form, the ballot language, how the language is worded, basically everything from before you even draft the ballot language to how the votes gets counted, everything in between has been regulated in that legislation. And so we've seen that legislation in a lot of states stall out, not pass, die in session, or die in committee. And so practically, since in the last 2 to 3 years, we've actually seen a lot more of this legislation pass and then be signed by the governor. And what that has meant is that a lot more litigation is happening around these restrictions, as you would expect. And so we've seen this particularly in Montana, where they're engaging in process to make sure that they're keeping their ballot measure process open. They're actually pushing forth a measure that would ensure that it stays open. We've seen challenges in Arkansas, also in Montana, Florida, Oklahoma, Missouri, basically every state that you can think of that has the initiative process. And in particular, we've seen them most in states where conservatives legislators control. And so practically, that is the trend overall that we are seeing. In particular, we've seen a few critical issues that I think are worth highlighting in these litigations. So first of all, in Florida, one of the litigations, it's Florida Decides Healthcare is the litigation title. And basically there are a number of things that Florida Decides Healthcare is challenging, but in particular, in Florida, in order to have the local authority verify the petition, you have to pay. The sponsor of the campaign has to pay for that to happen. In the past, it was 10 cents. In recent years, it was about 70 cents. And the recent bill that is being challenged actually created a system whereby the supervisors of election can actually charge around $4. They've just basically authorized them to make it much more expensive, and based on how they're defining costs, essentially. And so practically what that means in Florida is that if you are a ballot measure petition that is trying to get on the ballot, you are going to pay about $3 million or more in order to actually get on the ballot. And that's just for verification. That doesn't cover anything else as part of the campaign.
Talk about inflation, right?
Yes. So that is the first issue that we're seeing. And that litigation actually just went to trial 2 weeks ago. The trial ended. And so we will see what the judge says there. But that is a novel issue that we're seeing. And to give you a kind of a barometer of other states, there was actually in Montana, the only other state that we could find that charged for the verification of petitions. It was $4,000, and the Montana Supreme Court shot that down as unconstitutional. And so you can get the sense of our view of that, and hopefully that this judge will find it unconstitutional as well.
It has a really unusually strong First Amendment, if I recall correctly. That's probably one of the reasons why they stepped in there. Yeah.
There's a couple other points in these litigations that I wanted to raise too. So in Oklahoma, there's a number of provisions that they're litigating there as well. But in particular, there's actually one requirement where you can only get a certain number of signatures per district. And so that means that it's not just that you have to get a certain number of signatures in certain districts, right? A percentage, like a lot of states have, Ohio and Missouri and other states, but it's a cap on the number of signatures you can get in a district. And in my view, I think that is an unconstitutional burden on the freedom of association, because if you're that one person over the cap, your petition or your signature won't be counted, which is I've not seen that before. And it seems very much unconstitutional to me, given all of the case law we've seen on this.
Yeah, so that disenfranchises people in Tulsa and Oklahoma City that seems to be the whole reason behind it. Yeah.
Yeah. And I think practically we'll see how this litigation turns out, but I do think that there's a very strong unconstitutionality argument for it. So we'll see. And then the last one I wanted to flag was, I think folks are pretty aware that there are these mid-cycle redistricting efforts going on around the country, and one is happening in Missouri. And as part of that, the Missouri Progressive Coalition actually launched a referendum campaign to stop the mid-cycle redistricting process. And so basically they collected signatures, they've submitted those signatures to the Secretary of State, and now they're waiting for those signatures to be counted and determine whether there'll be a referendum in the spring or in the summer. And practically at this point, I mention this because the committee that is pushing the referendum forward, the sponsor, has actually dealt with several litigations in connection with the referendum. And so not only is it the ballot access litigation based on legislation that we're seeing go into effect, we're actually seeing in practice being able to use the process and getting challenged along the way. And so I think that is a different variation, but something people should be aware of as they are thinking about engaging in the process and seeing it play out.
So globally, it sounds like there's efforts to block access. There's litigation that's happening to push back on all of that. What are you thinking broadly? Are progressives being successful in stopping all of this? How much energy is having to go into this? What are your thoughts on that?
Ultimately, I think that progressives are working really hard to make sure that they are putting strong cases forward, that they are fighting against restrictions on the process. And in a lot of states, they're winning. I think courts are seeing these restrictions and these challenges for what they are. they are unconstitutional burdens on the right of the process, the direct democracy process. And practically, I anticipate there'll continue to be energy around making sure we can utilize the ballot measure. And ultimately, I've actually seen it actually energize the folks in these states to make sure, hey, this is a right that I have, and I want to be able to continue to use this right. How can I fight to make that happen? And so there's actually a lot of energy to make sure that's the case.
If anybody who's listening is going to Cleveland to the BISC conference, I know, Emma, you're going to be there. Are you going to present? I assume you will.
Yep, I'll be there, and I'll be presenting about compliance, which is so fun.
Hey, look, this is the pod for that. And
So fun.
I'm not allowed to have favorites, but Emma's my favorite of all of the presenters at the BISC conference. Here we go. Brittany, do you have any kind of final thoughts about where we're at with everything that we've talked about with the litigation update here? Just, it's a lot, but I'm just curious, do you have some kind of global thoughts as we wrap it up here?
Yeah, I think it's interesting with all these cases, we're seeing good progressive action, and then we're seeing some action that's contrary to the progressive movement. So the courts remain a good and bad force. It is the branch of government that seems to be where we're doing a lot of our work right now. And that's always going to be true, especially when the Congress is not taking as much action at the moment. So we always just recommend C3s, C4s, all nonprofits keep apprised of what's happening with this litigation. A lot of it is very slow moving, but then some of it is very rapidly moving. This ballot measure stuff, a lot of that needs to be heard quickly before the election. So keep an eye on that. But remember not to panic just because a case is filed. There is a process that it'll go through, and it might be lengthy, but keep an eye on it and have a trusted source of information. Emma, like Alliance for Justice, and your local attorneys and other nonprofits that you trust.
Courts, a mixed bag. That's my takeaway. Emma, do you have any kind of final thoughts before we wrap up?
Absolutely. So what I would say is we are in an uncertain time. And to Brittany's point, you should reach out to your counsel. We're here to help, to make sure you understand the law and are thinking through risks and to mitigate those risks. And for folks that are listening, come say hi at the conference. I would love to see you at BISC.
It's the best session. I'm telling you all, it really is. And compliance, super fun. It's what we do. If you are interested in more information, we've got it in the show notes. We got all of the cases that we talked about and some articles that speak to them as well. Thank you so much for joining. We will see you next time.
We hope this episode helps make you a bolder advocate. Join us next time for more ways to maximize your advocacy and make positive change in your community.
We're much more than this podcast. If you've got questions, you can email boulderadvocacy@afj.org. You might even get one of us.
If you found the show helpful, please rate us on whatever app you're listening to so others can find us. For more resources mentioned on the show, plus the show notes for the podcast, visit afj.org. Thanks for joining. A Boulder Advocacy production.